Okay. Good afternoon, everyone, and welcome to the launch of our evictions report that focuses on the magistrates' courts. I'm going to hand over immediately to our Executive Director, Nomzamo Zondo, to welcome you and to set the scene. My name is Lauren Royston. I'm the Director of Research and Advocacy at CERI, and I'll be back shortly after Nomzamo's words of welcome and scene setting, as I'm going to be your chair today. Over to you, Nomzamo.
Thank you so much, Lauren. Good afternoon to everyone who's joined us today. Would not take it lightly that you've given away your time to join us as we launch this product. I would like to thank you for joining us. I know that in the room, we have members of the judiciary, we have government officials, we have activists, we have legal and housing practitioners. And if we are lucky, we also have some students. And it is very important that all of us are together here to launch this product. As we all know, this year is in the midst of us celebrating 25 years of the South African Constitution, a constitution that is celebrated globally for its bold vision, which includes ambitions to improve the quality of life of all citizens and to free the potential of each person. 2 decades ago, that vision was enough to position South Africa as a leader in the attainment of human rights. But as we sit today, something more is needed. Questions are being asked, rightfully so, about the role of the Constitution in attaining that vision, but also more importantly, about how the Constitution impacts the lives of poor people. It is for these reasons that CERI undertook the evictions research series. And in doing so, we wanted to engage on the enjoyment of the protection against arbitrary evictions by residents of the inner city of Joburg. It is fitting that the focus is the inner city of Joburg, an area of land that's been formed and affected by laws from before Coastal dispensation. And in fact, even the changes through the law changed who was allowed to live in the inner city. But also more importantly, the report that we launched today focuses on the Magistrates' Court, a court that is the most familiar and the most accessible to the members of the general public. And as we sit today, we hope that in the discussions that we'll have, in you reading this report and the reports that we launched after it, we can all strategize effectively on the roles that we must all play to usher in the vision that is set out in our transformative constitution. With those words, I'd really like to welcome you, and I know that we are going to have a robust debate. We've got an amazing panel. I hope that you will participate through our chat, and I'm going to hand back over to Lauren. Thank you, Lauren.
Thanks, Nomzamo, for your words of welcome and for setting the scene to remind us about the importance of the Constitution and indeed constitutionalism in our country. At CERI and our research and advocacy work, together with our litigation colleagues, what we attempt to do is give voice to the people we work with, to our clients, to our partners, in order to provide support to their struggles for socio-economic rights. So when we launch a report like this, it's important to us that we hear from people in the launch about their responses, because this will inform us as we take our next step, which is always to find a way in partnership with others, in collaboration with the key stakeholders, to try and influence the change that our research reveals is needed. So with those a very few background words from me on the purpose of our research here at CERI, I want to make a couple of housekeeping comments. The first is, if you haven't already done so, please do introduce yourselves in the chat. Our program today consists of a panel of presenters, my colleagues Yvonne Erasmus and Narishka Singh, a respectively senior researcher and candidate attorney at CERI, will present the research report. It's a double act. I'll be handing over to them next. And thereafter, we'll hand over to Mbekezeli Benjamin from Judges Matter to respond. And after him, Siyabonga Mahlangu, our colleague and comrade at the Inner City Federation, to provide his responses. And then there will be a Q&A. So you're in safe hands. My colleague Edward Malopi and I are managing the time. The presenters will be informed if they go over, they know this. And we look forward to your questions and comments. Please don't wait till the end. Please provide them as you think of them in the chat box. And then we will, in the Q&A box, and then we will open up for hearing responses to those questions and comments. This event is now being live streamed, as you'll see on Facebook. We will also post a recording on our YouTube channel shortly after this event closes. So without further delay, I'd like to give you a brief background to the series before handing over to Yvonne Erasmus. So thank you. That slide again. The purpose of our research series, and this is the first report in a series of reports, is to review how the courts have been implementing evictions law. And in addition, we set out to map the spatial distribution of evictions in the inner city and slightly beyond its borders. Our scope is both the Johannesburg Central Magistrates Court and the Johannesburg High Court. Today, you'll be hearing about the first, the Johannesburg Central Magistrates Court. Our period of research is 2013 to 2018. And our focus, our geographic focus, is 12 wards in the Johannesburg inner city. So that, I hope, gives you a little bit of background to the series as a whole. And I'm now going to hand over to Yvonne and to Narishka. Yvonne will kick off the presentation.
Thank you very much, Lauren, for that introduction, and good afternoon, everyone. So our presentation today, which Narishka and I will co-present, is in 4 parts, and we will talk about the methodology underpinning the research, the legislative context governing evictions, the findings of the research, as well as the implications of our findings. So moving on to the methodology, as Lauren mentioned, the data covers a 6-year time frame, 2013 to 2018. The data for this particular report was collected in 2019. So we use a ward-based analysis, as this will allow us in future, as the series builds, to compare our data with other data sets that use a similar demarcation. So the city of Johannesburg has 135 wards, of which 12 fall within the official urban development zone, or UDZ, boundary of the city of Johannesburg, and are commonly known as the inner city. However, some of these wards exceed the boundaries of the UDZ, and the analysis therefore covers the inner city and its immediate periphery. So on the map, you will be able to see the overlay of the 12 wards and the UDZ boundary, with the boundary in the lighter color. On the next slide, that map depicts the 12 wards only, their boundaries, as well as a table with examples of areas included in the ward. And you'll recognize some of the areas associated with the inner city, such as Joubert Park, Hillbow and Yovo. So why are we focusing on the Magistrates Court? So the judicial structure begins with the lower courts. They are the most accessible courts to the public, and they hear a wide variety of cases inexpensively and faster. And because the cases heard are limited in terms of the monetary value, it makes litigation against individual households cost effective. It's also the court structure that attracts the largest budget and most resources. And we have 763 magistrates courts in the country. I'd like to frame our findings with a short overview of how the data was collected and what the limitations are of this work. So our findings draw on a combined data set that consists of two subsets. The first subset is case files stored in the Johannesburg Central Magistrate Court. So access to these files was granted by the Chief Magistrate of the court. We did not have access to the filing room, but was given appropriate files by the clerk of the court. And we collected 47 cases in this way. The second subset is sheriff's returns of service, particularly the Sheriff of Johannesburg East and the Sheriff of Johannesburg Central, as these are the sheriffs that would handle returns of service, so either a notice of an eviction proceeding or an eviction order in the inner city. So returns were received from each sheriff, and we collected 18 cases in this way that had originated in the Johannesburg Central Magistrate Court. So our total data set is 65 cases. What surprised us somewhat is that we found no overlap between the 47 and the 18 cases. And there are valid reasons for this. For example, people might have moved out on their own after an order for eviction was granted by a court without the sheriff becoming involved. But the lack of overlap does bring us to the limitations of the work, which is that there is no master list of eviction cases. So files might have been missed as they might not have been available on the day in the filing room for whatever reason. So although triangulation is important and we have attempted this, our numbers are still likely to be an undercount of court-ordered evictions. Nevertheless, our research provides important insight into how many court-ordered evictions there have been and how the courts have adjudicated eviction cases. I will now hand over to Narishka.
Okay, good afternoon, everyone. Thank you for taking the time to be here. I think the best place to start is with the Constitution. This is where we stem all of our rights and base all of our rights in. Most relevant to this research is Section 26, subsection 3 of the Constitution, which explicitly states that no eviction can be granted without an order of court. In order to give effect to this constitutional right, the legislation, the PI Act, was enacted. And the PI Act basically sets out the procedure that needs to be followed for an eviction to be granted. And it also importantly gives rights to people who otherwise have no legal claim to the property that they're on. So we refer to people in this situation as unlawful occupiers. Those are also protected explicitly by PI. On the next slide. So while we talk about the importance of legislation and the legislative context of the work that we're doing, it's really important to refer to jurisprudence. And there've been a number of constitutional court cases which deepen and expand our knowledge of PI and how it needs to be, excuse me, how it needs to be interpreted. For the purposes of our research, Kiribati is one of the most important cases we can rely on. And it's important because it expressly states that where personal circumstances in an eviction application are not available or not present before the court is empowered to refuse granting the eviction order on the basis of insufficient information. The judgment goes even further to emphasize the need for judges and presiding officers to proactively investigate the personal circumstances. And that is extremely important in cases where the respondents are not available or not in court themselves. Some kind of inquiry must be made into who is being evicted and under what circumstances. Okay. So as Yvonne has already mentioned, we cover 65 cases in this report. 18 come from the Sheriff's Return of Service and 47 directly from the court. It's important to look at both of these sources of data because the court's cases will give us more insight into how these matters were adjudicated. And the Sheriff's Return of Service expand our knowledge on what happened after the court, or if the court order was indeed granted. Please go to the next slide. Okay. So in defining what the inner city is, there's a bit of speculation around that. What exactly do we think of the inner city? There are some areas that we all think of immediately when we define the inner city, such as Hillbow or Yovo. But the 12 wards that we have are all sort of on the pie chart in front of you. From these 12 wards, we found eviction applications in 11 of them. There was only one ward that did not have an eviction application attached to it, which was Ward 58. 2 wards in particular stood out to us with the most eviction applications. So this was Hillbow and Yovo. It's important to add a little bit of nuance when you think about the cases from Hillbow and Yovo, because they weren't all separate or unlinked cases. In the case of Hillbow, most of the cases came from the same building. 14 of the 17 applications came from the same building, whereas in Yovo, they were spread across 8 buildings. 13 of the applications were spread across 8 buildings. So what I'm going to do now is present to you our findings. These findings come directly from the magistrate court files. There were 47 cases, and in all 47 cases, eviction orders were granted. This is important just to remember, because what we're trying to highlight is that PI doesn't make getting an eviction order impossible. What it does do is set out the procedure and how that eviction order must be obtained and what must be considered on the way to getting that eviction order to make sure that it's compliant with our constitution. So the first question we asked were the parties legally represented? And what we found was quite staggering. In 42 of the 47 cases, so that's 89%, only the applicant had legal representation. And this representation wasn't as varied as one might think. So 12 firms represented all 47 cases, and for one firm represented 31 out of the 47 cases. This is important when you're thinking about the nuance, and on a day-to-day handling of these cases, it essentially means that a very small group of people are in charge or handling the majority of eviction cases which come out of the magistrate court. Only in 9% of the cases, so that's 4 out of the total of 47, both parties had legal representation. And what we learned from this is that the lack of a legal defense, so that's all of your papers being filed plus representation on the day, really is detrimental to the people being evicted, more so than one may think. And that is what we're trying to highlight with this information. Okay, so the next question asked was whether or not the case was opposed. Opposing a legal application is more than coming to court on the day to state your objection if you don't have legal representation, for example. But what we found is that 40 of the cases, so 85% of the 47 cases were entirely undefended. This means that they had no papers filed on their behalf and had no one to represent them on the day of the hearing in court, which means that their personal circumstances or their version of events or any pertinent information they may have to present to the court was not done, they were not able to do so. The next question, or the next part of the story, is who are the applicants? Who are the people seeking eviction in these cases? Depending on your perspective or your exposure to different forms of eviction law, you might think of an applicant as an individual owner, a company, or some other variant of that. What we found is that 70% of the applications were brought by private property companies who are appointed to act as agents of large apartment buildings, for example. Fourteen of these cases were brought by individual owners. So in that, what that does is add more nuance to what we're talking about. Are we talking about large apartment buildings where the power dynamic is slightly different, or an individual person who's leasing out a property for secondary income, for example? The next and the most probably pertinent question to our research is, were the personal circumstances of the respondents being considered? This really provides context to the eviction. More than the dynamics of the leaser or owner of the property to the person living there, it really talks about how many it really gives information about the specifics of the people facing eviction. It's important to remember that this is not a consideration that is that should be taken for granted. It's required by PI, by Section 4 of PI. And an example of personal circumstances would be how many people are being evicted? Are there any minor children? Are there disabled people? Or even elderly people? These are all protected groups that PI specifically mentions to make sure that if people in those categories face eviction, the courts can take extra measures to ensure that their rights are also protected. Unfortunately, our findings were that in 94% of the cases, there was no engagement with the personal circumstances. We could link this to legal representation, but I think that's more, up for debate. What's important is that something that really needs to take part of an eviction application was not present in the majority of cases that we looked at. Okay. One of the other things we really wanted to find out is what the reason was for people being evicted. I think that it might be easy to think about the inner city and all the areas that encompass it and make assumptions on why people are facing eviction in these particular areas, whether it's an occupied building or apartment buildings. But what we really need to do is take a step back and look at the facts from the cases. And what we found was that 41 of the cases, so 41 of the 7 cases, which is 87%, were brought because of the non-payment of a monthly rental. This really highlights the importance of affordable rental, or the need for it, and also draws in a discussion about what makes rental accessible and how does that then play out in these situations. Only 5 of these cases concerned occupied buildings. So buildings where the people who live there have no legal right to the property, which would be, for example, a lease. Okay, so I think I'm going to hand over back to Yvonne now. She can take everyone through the last bit of our findings.
Thank you very much, Narishka. I think drawing on what Narishka's presented, which I must flag as a selection of our findings for the purposes of this presentation, there are more in the report. We think that there are really 3 key findings from this work. 2 of them are relevant for the judiciary and practitioners, and 1 is relevant for housing advocacy and state planning. Our first key finding really is around personal circumstances. And our findings have led us to conclude that the requirements of the PI Act are not being adequately implemented. So the absence of an inquiry into personal circumstances means that the orders for evictions do not meet the required standard of being just and equitable. The second key finding is around representation. So as Narishka indicated, respondents were severely underrepresented, and underrepresented respondents should be adequately accommodated and advised of their rights in order for the court to make the required assessment of their personal circumstances. The third key finding is really around why people are being evicted. So the overwhelming majority of evictions was for the non-payment of monthly rental, indicating the need for safe, affordable rental accommodation in the inner city. So what are the implications of these findings? Although we are not in a position to be prescriptive, and we respectfully put forward that an increased focus by the judiciary on how evictions law is implemented in the Magistrates Court is necessary. And this could, for example, include revisiting training provided to magistrates on evictions law. The judge president could perhaps issue directions for the adjudication of eviction cases. There could be monitoring by the Office of the Chief Justice if this is thought appropriate. And all of the above could include guidance on how to assess personal circumstances, how to accommodate unrepresented respondents, the need to join the city when evictions lead to homelessness, and the practical steps that can be taken if the city cannot reportedly fulfill this obligation, which is a real conundrum that arises, but there are some practical solutions to this. And although there's still uncertainty about this, it might be worth mentioning at this point that last year the Land Court Bill was issued that proposed the establishment of a land court and land appeal court to deal exclusively with litigation relating to land rights, which would include evictions. So in line with the findings of this report, it would be necessary for judicial officers to be appropriately equipped to adjudicate eviction cases, and for the wealth of jurisprudence on eviction cases to be acknowledged in the bill going forward. So what are the implications for the municipality? So research also has a few implications here. So the PI Act states that the city has an obligation to intervene in cases that lead to homelessness and provide temporary emergency accommodation. Securing this accommodation is often very difficult without legal representation, which we saw very little of in our findings on the Magistrate Court. And therefore, we would like to see a more proactive and planning approach rather than a responsive approach on the part of municipalities. And finally, we think that our findings hold implications for changing the narrative. The inner city is often described as in need of regeneration, with the idea of en masse unlawful occupation taking place. We argue that that is a harmful narrative, both to individual households and for public perception of who resides in the city. Our findings as to why people are being evicted in turn point to a lack of affordable rental options in the city as a key challenge, which is important for housing advocacy going forward, but also points away from harmful narratives of who resides in the city. So that concludes our presentation on this report, and we welcome any feedback as well as engagement on the way forward. Thank you.
Thank you to Yvonne and Narishka for their presentation. So there you have it, an outline of the method, the findings, a summary of the findings, and how we see the implications. I've noted that there are comments in the Q&A. Please continue with those. We are keen to hear them and we will respond, but we really do hope for a dialogue as well. If you have any additional comments or questions, please do note them. Please keep doing so. Thank you. So I'm now going to hand over to our first respondent, Mbekezeli Benjamin from Judges Matter. Over to you.
Thank you, Lauren. It's funny that you call me the first respondent. I hope I am represented in this forum. As we've seen in the report, most first respondents are not represented, in fact. But I think this is a wonderful project. This report, I think, is timely and important. One of the things that I've noticed, first from my time while I worked at Syria and later now that I work directly with judicial officers, is that often the magistrates' courts are such an important part of our judicial system, but they're so under-researched. So this report is a powerful and useful contribution in thinking about what happens in the magistrates' court and understanding what are the challenges that people face in that system. The second thing that jumps out from the report for me is the sense that I get that the role of the judicial officer is central in all of this. As Narishka and Yvonne said, the respondents, the people who are being evicted in these cases are often unrepresented. And you'll find, well, the report says that you'll find that in most of those cases, the other side, the landowner, is represented. And so the challenge is on the judicial officer to try as much as possible to assist the person who is representative, who's being evicted. And that is something that the PI Act and the Constitution requires of the judicial officer. But as the report disappointingly says, is that the majority of cases, the personal circumstances of the very people who are being evicted are not taken into account. And this speaks to the compliance with the law, which, as Narishka pointed out, the Kiribili case of the Constitutional Court said that an eviction order cannot be granted unless someone's personal circumstances are considered. So the role of the judicial officer is emphasized time and time again through different parts of this report. And one of the things that we at Judges Matter and our sub-project Magistrates Matter that we've tried to sort of figure out is, what is it like from the other side? What is the view from the side of the magistrates who have to deal with some of these cases? We've been scratching our heads for a number of years. One of the ways that we've tried to find out is to go to magistrates' interviews. We've sat in those interviews and understood what kind of considerations go into someone coming in as a magistrate. And one of the things that we were concerned about is we got a sense that there were a number of candidates who were already acting as magistrates who did not really have a firm grasp of the law, and that concerned us. And so we decided to then go ahead and do a lot of research, pointed research, to try and understand the environment in which magistrates work in. And what the product of that research was a survey that we conducted sometime in 2019, where we surveyed about 165 magistrates across the country. And those magistrates were a diverse range of magistrates. Sorry, my slide is not participating, but it was a diverse range of magistrates. It was a representative sample, and I must say it was only a sample of the magistrates. And we asked them on a number of questions, including on safety, on infrastructure, their stress levels, their workload, the resources that they have. And the most important thing was the kind of support and training that they receive in order to adjudicate cases. We found that half of the magistrates said that discussing cases with colleagues is one way of offering them support, and they found that as an important intervention in trying to equip them in dealing with some of the cases. But we only found that 43% of those magistrates said judicial training is adequate and satisfactory. So this speaks to one of the key findings from the research report that we've just heard now, that there might be an issue with training, and perhaps this is something that needs to be explored, because both of these reports are now speaking to a common thing. And then we found that 6 out of 10 magistrates, which is about 61%, said that the stress levels that they're under affect their ability to work. So it's not only the knowledge of the law or the accessibility of the law and understanding how to apply it in practice, but also the stress levels and the pressure that magistrates are in. So I think this is part of the context in which we need to understand some of these findings. And this is not to say that all the magistrates in the magistrates court do not know the law or they do not know their jobs. I'm certainly not saying that, and I trust that my colleagues at SERI are also not saying that. But it does speak to certain concrete action that needs to be taken to better equip magistrates and perhaps other judicial officers in understanding how the Prevention of Illegal Evictions Act applies and what should be considered. Because, like I said, the Kiribili case is a recent judgment of the Constitutional Court, and there the key finding was that the personal circumstances of the people being evicted must be considered. So if that is not done, the Constitutional Court said, the eviction cannot be granted. And this is something that we need to reiterate time and time again. And part of it is in bringing the training. So I welcome this report, and I congratulate my colleagues, Yvonne and Narishka and the team at SERI for bringing this report to light. And I'm sure that through these conversations, and I'm proud and I'm really happy to see so many magistrates all the way from Namibia, Butterworth, Durban, and other places have come to attend. This is important. We need to start this conversation and carry it on so that we can see tangible improvement in the courts. Thank you.
Thank you very much, Mbekazeli. It's very gratifying to hear you comment that our research report, in fact, contributes to a research lacuna, and we do hope that we can engage further with you and indeed with magistrates on identifying how we can take some of the implications forward, and indeed the common findings around training. And I also noted some of the other points around discussing cases. But certainly we are on the same page as you. We certainly aren't suggesting that magistrates are all untrained, but we are looking to highlight how we could contribute to improvements. So thank you very much. I think that we should hear now from a different perspective. You've heard ours on the research findings, looking at the court data and what we feel the implications of that are. You've heard something from the other side of that perspective, which is from Mbekizeli at Judges Matter and at Magistrates Matter. And now we'd like to hand over to Siyabonga Mahlangu, who is with the Inner City Federation. The Inner City Federation is an organization, a community-based organization based in Braamfontein. As is Siri, you would have heard some of the noises from the street, I think, when Narishka was presenting. The Inner City Federation is also based in Braamfontein and have a wealth of experience in terms of people who are attempting to access the courts and access justice through the people that are really walk-ins that come to what is essentially a community advice office. So it's with great pleasure that I now hand over to you, Siyabonga, for your responses.
Thanks, Yvonne. Thanks, Lauren, for giving me this chance to talk about the experiences that we are facing as the victims of evictions, especially around the inner city. In the way that I've been advised in so many years when it comes to eviction, the way that the magistrate court handles the eviction applications from the start until to the end of whereby they're granting the eviction order, it's not in compliance of the PI Act. If the applicant brought an eviction application to court, there are some things that they should be considered as the PI Act and the Constitution says, but those things we feel that and we see that they are not considered. I would like to pick some few cases that they brought so much pain to me when the order was granted by the Magic Court in Johannesburg Central. I even cry in one of those cases because I knew and understand that this eviction is going to lead these people to homelessness. There is the case of Simpiwe Mbonambi versus Johannesburg Housing Company. This is the woman-headed household, which is made it clearly by the PI Act that says if ever the presiding officer presides the matter should consider the personal circumstances of a headed woman household. But in this case, those were not considered. Even the rights of children were not considered. Instead, these people, they were being allowed to file their personal circumstances, which proves that their eviction order will lead them to homeless, which they did. In that circumstances. That woman was having a medical issue, that number one, that was supposed to be considered, but it was not considered. That woman was not employed, this was unemployed. Then she was only relying on a child's grant, but all those was not considered. And then when they were granting the eviction order, they also granted that one in a violation of the human right, in a way that they granted that report without having the city report in front of the court saying that these are the findings. This lady can also accommodate herself together with her children. This hearing, the whole hearing was happening without, in the absence of the city of Johannesburg, which is the city that have got a jurisdiction when it comes to eviction around the inner city of Johannesburg. That eviction order was granted, and then I even said to the clerk of court and saying that we were thinking that the Magic Court is a hub to serve justice, but now we see is that the Magic Court is a hub to oppress the poor people. Then what we did there, we said, okay, it's fine. We did apply for a leave to appeal, which was not granted to us when we were assisting that particular lady. We went straight to High Court, whereby the leave to appeal application was granted. That matter, even today, is still ongoing because the city did their constitutional obligation to ensure that everyone has the right to access to adequate housing. Then they find out that in their findings that this lady can't help herself together with her children. They have to intervene as the city and assist in that. While else, the Magic Court granted an eviction order without considering all these relevant personal circumstances of this lady, which is something that is very, very important when it comes to PI Act, even in the Constitution of South Africa. So on that particular day, I started losing hope of depending to justice and say that there is the justice here in South Africa. I said, no, maybe justice is being served to certain people. And then we've got another case whereby the respondent was a man which was not working, who was retrenched in her work through the pandemic of COVID-19. That man tried all his best to try to have a meaningful engagement with the landlord. But what happened is that the landlord refused to engage with that particular man. Whereas the PI Act says that meaningful engagement is one of the requirements before even the hearing takes place. We even raised that with the court and said that here are the steps that we tried to take so that the meaningful engagement can take place. But the court didn't want to hear that out. And we even said that, yes, we do understand that that person he bought that particular property because he wants to make profit out of it, yes, but now we can't allow that such eviction to be granted because this man together with his family, they are going to render on the street. But the answer that was given there, it was painful also, saying that you left your home where you came from thinking that you'd get something for free here in Johannesburg. So I said to the clerk of the court, but that's why there is the PI Act in place to protect those people who can't protect themselves. And there is the constitutional obligation when it comes to City of Johannesburg that they are making sure that they protect and promote and fulfill the right that are arising in the Chapter 2 of Bill of Rights of South Africa. Then in that instance, to us as the Inner City Federation, we took a large and a decision saying that we are no longer going to take our cases straight to Magic Court. We are no longer going to work with Magic Court. We'll rather sit and advise the victims of the eviction not to attend the court so that they will grant that eviction order in their absence so that we can be able to shift that case from the Magic Court to High Court, because we've got that belief that in High Court, they've got that legal understanding. When we've got no legal representative, we appear by ourselves as the resident. They do listen to our story. They do consider some relevant facts of the hearing and of the application. So at this point, maybe we'd like to say thanks to Seri by doing this research and expose such things, because whenever we are trying to voice out, no one listens. Instead, if you're asking, okay, where can we complain about this thing? You'll be told that no, you can go wherever you want to go to. You are not even given the direction where you can go and say, this is the issue that we are facing. How can we get helped? So we are like to say thanks to Seri to give this opportunity to us as the pro-poor people to voice out and then to share our experiences through the eviction processes in the Magic Court, especially. Yes, there is some challenges in High Court, but not that much like in Magic Court. In Magic Court, we are no longer having the belief that they are put in there to serve justice. We've got the belief that they are put in there to oppress the pro-poor, because they can't even represent themselves properly, even though they've got that little knowledge of how to defend the eviction, but it will turn out like they didn't do anything, because all the effort and the resources that they exhausted to try to engage with the Magic Court will become like no fruits, will be like non-fruitful. So we like to say thanks to Seri in this instance for bringing such event so that we can share. Maybe we'll be here and then we'll be assisted. Thanks. I would like to hand over back to Lauren for now.
Thank you very much, Siyabonga. It's important that we hear some reflections from people who are directly engaging, like the Inner City Federation, with people who are on the receiving end of experiences with trying to access justice. It's important that we hear about the frustration and struggles and indeed heartache, as you mentioned, Siyabonga. It's disheartening to hear about the loss of belief that you express in the Magistrates Court, and it's part of the reason why we're here and part of the reason why we've undertaken the research. I'm now going to, so thank you, and thank you to all four panelists. The way that we're going to proceed with the next round, the next section of our program, is to start with the first round, in which we're going to take some responses from the panel on the questions that have been posed in the Q&A. I've been looking at the Q&A and I haven't been monitoring the chat, but I'm relying on Loretti Mumba and Edward Molopi to feed me some of that. When it comes to the Q&A in the chat, to me, it seems that there are a few key issues that are emerging. There are a series of questions about representation that I would like the panelists to choose to respond to, but not to duplicate responses unless they have a different response. So the questions about representation pertain firstly to the minority of cases, which were around the relationship between where there is representation and the dismissal of an application. I think that is rightfully handed to our researchers on the panel. So either Yvonne or Narishka. I said I wasn't going to allocate, but I just have. That seems an obvious allocation to make though. Then there are a series of responses and comments from Dr. Mhlanga around representation. So the mere fact of not being represented does not mean that judicial officers won't help present. There's another, present the circumstances. There's another comment or question about oral evidence being given. So there are a bunch of questions there about the role of judicial officers, which we need to hear responses to. There are also a range of questions that link to personal circumstances, which we need to hear some feedback on. There's some methodological questions, which our researchers again can respond to. And then a comment about the role of municipalities and how indeed municipalities should be involved. So I'm going to hand back first on that round and collection of issues to Yvonne and Narishka to begin with, and then to Mbekezeli on the role of judicial officers and the comments that have been made in that respect. And then Siyabonga, I'd like to ask you if you have any comments to make on the role of municipalities. So over to the panel. Thank you. Yvonne, do you want to kick off, or Narishka?
Sure, Lauren. I think I've just unmuted, so let me kick off. I just want to thank the audience for their fantastic engagement and for posing some challenging questions that we really need to, that is food for thought and that requires some serious consideration and engagement. I think I'd like to take some of the questions, and I don't want to duplicate with what Narishka might want to say, but just on the question around representation and dismissal, and Narishka can correct me if I'm wrong, as she collected the data for this particular report. But in none of the cases that we have, none of the 47, even where there was representation, were any of the evictions or were any of the cases dismissed. So even with representation, eviction orders were still granted in all of the cases. There are questions around methodology. So there was a question in the Q&A around how easy it is to determine personal circumstances. So what criteria we would use and how easy or not that would be to do on a larger data set. So it basically, and again, Narishka can add, but it involves looking at the case files and extracting answers to a couple of questions, such as, do we know who is being evicted at a very basic level? Do we know the size of the household? Do we know how many people reside in the household? Do we know how long they've been there for? Do we know whether there are any children living in the household, any persons with disabilities? Is it a female-headed household? Will there be any disruptions? For example, will children have to be taken out of school if an eviction order is granted? And most importantly, will homelessness result? And are people employed, and do they have an alternative? Do they have somewhere to go, or is the alternative the street? It's not difficult to do on a case-by-case basis. If we have systematic questions or questions that we systematically extract data on. We've also done it on or are busy doing it on our High Court data set, so that the data collection has already been concluded on that, and we went through a similar exercise, and that data set runs into between 300 and 400 cases for the Johannesburg High Court, and we were able to do that on a larger data set as well. And then I think I will just briefly respond to some of the comments by Dr. Mlonga in the Q&A. I think Narishka will be in a better position to respond with a legal background, but I think that we actually agree on quite a number of points, Dr. Mlonga. I think we agree that the PI process does not just protect tenants, and it shouldn't just protect tenants. It's a balance of rights, and I think we agree on that. And I think we agree. Also agree, and thank you for pointing that out, that the magistrates do receive quite comprehensive training through the institute that you mentioned, and I think we also agree that the magistrates, that there are magistrates who are applying PI and who are under very difficult circumstances, that Mbekezeli also pointed out, doing their job with an enormous caseload. And who have to make very difficult decisions. So I think we agree on very many points. And we are also not saying that these findings apply to all magistrates in all courts in all time. But I think where we differ is that we cannot get away from the fact that we investigated in detail 47 cases. And again, as I said in our limitations, that there might be cases that we missed because they were not available in the filing room at the time. So we acknowledge that. But we can't shy away from the fact that we looked at 47 cases in depth and we found what we found. And the findings are concerning. And again, it's not about, we're not here to point fingers. We are here to try and work out what the best way is to support magistrates and judicial officers to do their jobs, because I think we are all in the same boat, and that is to work towards the realization of the Constitution and to allow people to claim the rights that they are entitled to, but also to enable judicial officers who have to make those difficult decisions to enable them to do that within the context of the workload that they have and within the complexity of the legislation that they have to apply. So I'll leave my comments there. I'll hand over to Narishka. Thank you.
Okay, thank you, Yvonne. Again, thank you everyone for your questions. It's really great to see people engaging with the work that we've produced. I think I'll start with the personal circumstances questions and then maybe move into some of the other things that were raised. And after I'm done, I think one of the other panelists can feel free to jump in. So the question about getting the respondents' personal circumstances if they were not legally represented is actually a very good question. Usually, if there was legal representation, let me start there, we would look at the answering affidavit that they would produce, because in the answering affidavit is where you would find the personal circumstances of the respondents of any application, and specifically in an eviction application. That's your opportunity as a respondent to say to the court, this is who I am, this is who we are, this is who my household is, and these are the circumstances that we live in or under, and what has happened to find ourselves on the other end of this eviction application. Where that was not the case, I think what becomes relevant to remember now is that most of the cases that we came across were on the basis of an unpaid rental amount. And so the applicants in that situation would produce a copy of any form of lease agreement. Most of the time, lease agreements were present in cases where there was a big building, a property agent managing the eviction application or the applicant of the eviction application. From that, we were able to at least get a name of a person who had signed the lease agreement. But the thing that stood out to us, especially when we were collecting the data, was that the next paragraph or what would be put before the court is explicitly that the applicant would have no further knowledge about who lives under this person in the unit, and therefore they're not aware of any other personal circumstances. We also, because we were in the courts, accessing the court files, we had access to the entire file, which included any notes that the magistrate or presiding officer would have made on the file. And included in those notes would be who would be in court or what happened if on the day of hearing. So we're in cases where we say that we have absolutely nothing, what you're looking at or what we're likely to believe happened in those cases was the fact that nobody came to court on the respondent side, including the respondents themselves. And because of that, no representations were made on their behalf. And those were not necessarily things that we included in the research by taking down those specific instances, but that's how we got to that finding. I hope that answers that question. Okay, and then I'll just move on to Dr. Mhlanga and your comments. I agree with everything that Yvonne said, and most of the comments and questions that you've raised are quite correct. PI is not there specifically to guide unlawful occupiers or people in breach of or facing eviction against anything that could happen to them, at the detriment to anybody who has rights in any property dispute. But what it is there to do is just provide a platform for which these rights should be navigated and a procedure on how the eviction order should be, what should happen before the eviction order is reached, or the stage of the eviction order. I think for us, from the side of the research that we found, what we've, sorry, I just lost the question for a second. So, I mean, what we're trying to highlight is that while the balancing of competing interests is extremely important, and in fact, in all the cases that we found, eviction orders were granted, and that's not necessarily something we're disputing as incorrect or correct, but the manner in which that was done is something we're trying to highlight. Just because at the end of the day, our law is explicit in the fact that homelessness needs to be avoided. And so it's important to interrogate what happened, when this order was reached, and what were the consequences for the people facing the eviction. I think.
Anything else, Mariska?
Okay, yeah, that's all.
Okay. I wanted to ask Mbekazeli to come in with comments and responses now, but just bear in mind that we do want to have another round. Thank you, Narishka and Yvonne. Over to you, Mbekazeli.
Yes, just two short, sharp comments from me. It's just the question of the how the law is applied. I think what we are sort of guessing from this report, I don't think we can draw any strong conclusions, but one of the factors that we are aware is that there is inadequate training. Training is provided absolutely to judicial officers, but like I said earlier, in the research reports that we did with the magistrates, where we surveyed magistrates, we spoke to the magistrates themselves, only 45% of them said that the training that they had received is adequate. So I think that speaks to a broader question, not only of individual anecdotal circumstances that we might be aware, but it speaks to a broader issue with the training as one of the support mechanisms. The other support mechanism that I spoke about is this idea of colleagues speaking amongst each other as one way of sort of learning some of the ways in which to approach some of these questions. And this particularly relates not to big courts like the Johannesburg Central Magistrates Court, but we are aware that there are one-man stations, for example, the court that only has one magistrate, and that magistrate doesn't really have an opportunity to engage on issues of power and how that applies amongst other colleagues. So I think that's another issue. But I see there are 2 points that speak to the role of legal aid in all of this. I think one point was raised by Hussein Kota, and the other was raised by Marion Vessels about the practical challenges of legal representation in some of these cases, that legal aid is sometimes called on board to assist in some of in either defending the evictions or even bringing some of the evictions. And sometimes there is a challenge, and the suggestion I think that I get from Marion Vessels is that legal aid should be brought on more to deal with some of the civil cases as and when they come through. So the clerk themselves referring, I think that's a useful suggestion, because it also removes some of the pressure of the judicial officer that he or she is the only one who now has to consider all these factors, and at least having another person on the other side. So as we know, our system is adversarial. So having both sides presenting or making submissions to the judicial officer, it does reduce the pressure that they have on their shoulders. So those were my comments for now. Thanks, Lauren.
And many thanks for them, Mbekazeli. I'm now going to pass to Siyabonga to see what comments or responses you would like to add before moving into another round. Thank you. Siyabonga, anything on your side?
Yes, Lauren. The things that the comment that I would like to say is that the magistrate court should make sure that the city act positively to protect and promote and fulfill the right that contains in Chapter 2 for human rights, which are those rights that comes like human dignity, right to equality, right to security of the person, right to access to adequate housing, because that's the main right when the eviction application is being brought to court, that the major court and the city officials has to make sure that the respondent does enjoys the mostly, because without a home, there is no life. Even though the life will be there without a home, but the life will be difficult. So I would like to say that they should make sure before even the hearing that they even order, compel the city to act proactive in such cases, because what's usually happening is just that the city, they will be cited in the application, but they will ignore the citation, the application, because they know that the eviction application order will be here and the order will be granted in their absence, and nothing will happen to them. No one will hold them accountable for not participating in such a hearing. So I can be glad if the presiding officers make sure that this city duty that they are performing. Thanks, Lauren.
Many thanks for those comments and for making the important point and reminding us about the fundamental rights that underpin the other socioeconomic rights. So thank you very much, Siyabonga. What I'd like to do now is ask my colleague Ed to flight the questions for those of you who haven't yet seen them. I know they were flighted earlier, but we were also listening to responses. So Ed, could you put them up and just flip them fairly slowly so that all attendees have a sense of what the questions are that were posed. Thank you for doing that. And what I'd like to do now is to make a couple of comments. So from an organizational point of view, yes, Siri works outside of Gauteng province. We are demand-led, meaning that we need to get a request. We have a system and procedures in place for dealing with requests that come our way. Secondly, I would like to say that Siri, yes, Siri does work within the City Federation. We're not the only lawyers that do so, but yes, we do. And then I want to make a comment on what has surfaced several times in the course of this discussion, which is how to be practically responsive to the constraints that our report highlights. And to this end, I'd like to ask Nomzamo Zondo, our Executive Director, to come in on the question of what can practically be done in cases where there's no representation. So Nomzamo, over to you for that quite broad question, but which I think touches on several questions that were asked, as well as some suggestions that were made in the Q&A and the chat. Nomzamo.
Thank you, Lauren. I mean, interestingly, I think Buti and Mashiane, and I think even Sia in the last comment, were quite clear that the municipality has a role to play. In fact, in our experience, when people have come to the High Court unrepresented, the High Court puts pressure on the municipality to play the role that it has been obligated to, which is to make sure that if people are facing eviction, that actually it brings information to the court about who those people are, what their circumstances are, how it can assist those people. So the reality is that the fact that the people are unrepresented is not a barrier to safeguarding their rights. I think one, it has been done by other judicial officers who say, I'm here, I have a property owner, but I not have the respondent before me. The best thing that I can do, one of the parties is the municipality. The municipality is in a small municipality would be someone who's able quickly to go and check at the address of the occupiers, engage with them, why they haven't opposed the eviction, what the circumstances are, and file a report. So in the very same way that in ESTA, there's provisions for that report, in PI, the courts have used municipalities to bring that report to the fore. And secondly, I mean, I think I'm less optimistic about engaging legal aid SA. I think for a long time, as our sector, we're trying to engage them about taking part in representing people who are facing eviction. And the first thing they raised was that they don't have enough resources. We know that even last year, there were discussions about adding the ESTA evictions onto their books, and there was special funds set aside to support them. But two, unfortunately, they fall into the trap of believing that once a person is an unlawful occupier, they don't have rights that need to be protected. So I remember last year when we made submissions on the land courts bill, one of the submissions that we made was that legal aid staff would have to be trained around PI to bring them to the realization that the court, I think, clarified for all of us in the Kiribili Koshal court judgment. So I think as a magistrate who's sitting in a court dealing with a matter that's brought via default, you have to, of course, make a decision of whether or not the person is an unlawful occupier or not. And if you don't have that information, you should, one, call upon the owner to give that information, because the onus is on the owner to prove that the eviction is just and equitable. So the owner must give you the information that they have access to. When that fails, then you are expected and you have a right to call on the municipality in whatever the area that you are in to bring that information to the court. And then only at that time, you'll be in a position to make a final decision. I think in cases where I've seen it work. And also, I mean, we do know that it's not in every case that people even want to defend. At times, maybe people do come to court and say, actually, I want to consent to eviction and I want to move out. And that's fine. But the challenge that we have is that we actually don't have that information. And what the court has said, and clearly in Evan Beria, was if you don't know, you can't make an order. So if we can't find it in the court file, who lives there? What is their income? What are their specific substances? We actually don't have the power to make an eviction order. And I think one of the ways that you can get that information is to bring in the municipality. Thank you, Lauren.
Thank you very much for that, Nomzamo. I think that we have aired questions around representation fairly thoroughly. And I feel confident also that the questions on method have been responded to. With the last input from Nomzamo and with Siaz, I think we have also responded to the role of municipalities. I wanted to add that we have a few more minutes and we would really like to hear from magistrates in the room who haven't commented yet in the Q&A. And we'd like to do that by requesting that you raise your hand. So there is now a few minutes, not very many. I'll have to really look carefully at how many we can take depending on how many hands are raised. But we'd very much like to have a moment now for vocalizing questions. So please do raise your hand if you would like to do so. While that's taking place, I wanted to say that a colleague from Namibia raised a question. Please feel free to contact us directly after you've had a look at our website, because our website does direct you to the case law. And there are resources on the PI Act in South Africa, which might prove to be useful to you. We certainly hope they do. So please have a look at that, but do feel free to be in touch. And then I just want to check if there aren't at this point. I've just noted a comment about the complexity of the law. So I don't see any raised hands. So what I'd like to do is give the panelists, before I do that, I'd like to check in with my colleagues on the panel, the people in the background, Ed, Loretti, if there are any questions that you feel we have failed to answer that I haven't picked up from the chat. And while you're doing that, please send me a message in that regard. While you're doing that, I'd like to hand back to the panelists for any further comments they'd like to make in terms of closing. You've got a little bit more than a minute or two each to do so. While you're thinking of that, I'd like to respond to, from my side, respond finally to a question that was posed about what the next steps are. So our next steps are, firstly, we will reflect and review on the questions and comments that have been made in order to inform our advocacy strategy. And for us, advocacy is essentially about the next steps. And what we've got to date is that training is important, not that no training has happened by any means, but magistrates training and legal aid training emerges as quite significant. So that's something that we'll be turning our attention to. We are not ourselves trainers of magistrates, as you'll realize, but this is where engaging with relevant stakeholders becomes really important to us. We also note the Judges Matter comment that Mbekazeli made, finding from their research that the question of discussing cases is important. And we do hope that some of our materials may assist in guiding in that process. But we'll take this up afterwards in terms of next steps. Another important point to make about next steps is that we will be releasing our High Court findings, which are a larger data set, which add texture and nuance to the set of findings, but also confirm them in important ways. So between now and the launch of that report, we will be engaging further with key stakeholders on some of the practical implications around what next. So thank you for that question, which gives us an opportunity to provide the sort of one of the concluding comments I wanted to reiterate, which was about what the next steps are. So I think that the important thing now, I'm just checking what my colleagues have said, but I would like, so the one thing that we'd like to know is that there is a question on from Priyanka Pillay on forms. We're not entirely sure what forms you are referring to. So Priyanka, could you clarify either directly vocalizing or in the chat what you mean, because we haven't been able to fully understand or comprehend your question. We've noted the comment about landlord-tenant training. We'll put that into our sort of collective pot or pipe and see where we go about that. We are aware we do have some materials on knowing, for tenants on knowing your rights. The Inner City Federation does deal a lot with rental cases as well. So firstly, Priyanka, can I ask you to come back with a clarification of your question? Is Priyanka still in the room?
Yes, hi.
Hi.
Sorry, I wasn't, I'm a researcher, so I didn't know the technical names for the forms, but I think, so one of the issues discussed was that there's the majority of respondents, or not respondents, the majority of people being evicted were unrepresented. And so they didn't have lawyers who could then respond to just say the notice to vacate with forms around their circumstances. Like if there's a particular form you have to fill in. So WeWork, or Open Up, is a civic tech company. And so I was wondering if there's standard ways of filling in those forms. That is there a legal requirement that lawyers must respond to the notice to vacate, or the other legal processes? Is it like a lawyer must do it? Or if the citizen themselves can fill in that form and we can just create a system that guides them on how to do it? That makes sense.
Yeah, it certainly does. And thank you for responding so gracefully to me, putting you on the spot like that. Apologies for that. There are materials on Siri's website, and Bekezeli's posted in the chat about that. That may be of assistance, but I'm going to fold a response into that. Thank you for the clarification, into the final comments from the panelists. I think we've adequately addressed the comments. We'll take them on board. You'll be hearing from us again soon. And over to the panelists now for closing comments. I'm going to start with Mbekezeli, then go to Siyabonga, then go to Narishka, and end with Yvonne. Thank you.
Thank you, Lauren. Just on closing comments, firstly, I'm, like I said earlier, I'm really encouraged by the number of magistrates that I see participating here. It's really encouraging because part of the work that we do as Magistrates Matter is to try and understand how the system in the judiciary works, how the judicial officers and the system itself work, and how it can better serve the people in South Africa. So it's really great to hear or to see them coming onto a platform such as this and participating. But I think on the question of the research, like I said earlier, the magistracy is an under-researched area in our law. We don't really have current thorough research on some of these issues. So we're basically swimming in the dark. So research reports like this do help us understand a little bit more on the picture. And I think one of the experiences that we as an organization, as Magistrates Matter, have gotten from doing some of the research and engaging with the magistrates themselves is that through what we find and what they also bring to us, we sort of get a more clearer picture of what's going on in that system. So I do encourage Siri and the magistrates and all of us to keep this conversation going. I look forward to the next reports or the next installments coming up next. And yeah, I look forward to more conversations on this and other topics. Thank you so much.
Thank you. Siyabonga.
Thanks, Lauren. I would like to also thank Siri again to conduct such an event so that we can share the experiences and the view and perspective on how the eviction cases should be handled. As the ICF, we are saying that the magistrate court can use us as their instrument to enforce the personal circumstances of the people whose their personal circumstances are unknown to the court or to the property owner. Then maybe you can assist on that particular one to make sure that the relevant information is being placed in front of the court before an action being taken. We also saying that you are also willing to have some such workshop together with them so that it will help in future for them to understand the situation on the ground and not only the one that is documented in a way of a law book, but also to understand what is happening on the ground so that whenever they are dealing with such cases, they will be having that much understanding, and then they will also use their humanity to also to take on the case before they also even grant the order. Thank you.
Thank you, Siyabonga, and over to Narishka, and then lastly Yvonne.
Okay, I think I'll just take this opportunity to also say thank you to everyone who's taken the time to listen to us and be here today. I think I'll quickly respond to that question just on the prescribed forms. There is no prescribed form on how to fill out personal circumstances, but what there is, there are just categories in the legislation which are highlighted as protected, and your personal circumstances could really be anything that's important. So using the guides possibly off the website and any other resources you may have, you can formulate what is important to your case, and then put that in an affidavit. There's no form to fill out. I think just for closing, I want to say that evictions are a response to a much bigger issue. I think that if things were working out the way people wanted, both parties wanted, there would be no eviction application to begin with. And throughout the process and engaging all the legislation, there are different points of intervention that different people can do to make sure that even if an eviction order needs to be granted, it can be done in a just and equitable way, which is the standard of PI. I think, from the moment of service all the way to encouraging citizens, even if they can't access representation, to come to court and place their personal circumstances before the court, capacitating NGOs or pro bono services, and making sure that the personal circumstances, or reiterating the importance of placing those personal circumstances before the court, are all things different people can do cumulatively to make sure that the end result is not homelessness. And that also obviously includes encouraging the municipality to come on board in an active way. So I think those would be my closing arguments, my closing points. There's a role for everyone to play in this. And I think what this research highlights is the nuance in evictions and the importance that everyone comes to the table to do their part. Thank you.
Thank you, Lauren, for the opportunity for closing comments. I think I would firstly like to thank all the judicial officers for the work that they do under very difficult circumstances. I would like to thank all of the participants for your incredible engagement today and for challenging us on various fronts. I feel that it has been robust. I hope that the webinar has provided the reflective moment that we were hoping it would, reflecting on how things are going, and also taking a moment to pause and think about the way forward and the role that each and every one of us can play, so that the protections afforded in the Constitution are there for everyone, and so that the Constitution can in the end fulfill its transformative aim. Thank you.
Thank you so much to the panelists for those closing comments. There really is very little left for me to say. So eloquent were they in providing those comments. So I want to formally close the launch. Please do look out for the next installment. And we hope to continue to engage with the various stakeholders that are essential to the vision of just and equitable outcomes that our Constitution and law demand. So thank you very much to everybody for attending. Goodbye.